not see the prosecutor, she often also not see her, and she also has to walk.
State Court case number B300, stroke 2026, straight versus Fannie Nkosi. The date today is the 13th of April 2026. Presiding officer Mrs. Piledi, prosecutor Advocate Sofonyana. The interpreter is Ms. Kosana. The accused person is represented by Mr. Blali. The stenographer today is Ms. J. Dover. And this matter is on the roll for formal bail application. Your Worship, the state submits that this matter falls under the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977.
Right, for the record state that we need to proceed today with the formal bail application.
The state is ready to proceed.
Thank you.
Thank you.
Who is representing the accused person?
May it please the court, Your Worship. Initial is S. Surname Lali, DLA-LI for the accused. I'm instructed by Nkome, Attorneys Incorporated in Hatfield. I'm here with Ms. Nkonyane from Nkome Incorporated Attorneys. As a court, please.
Are you also ready to proceed?
I'm ready to proceed, Your Worship.
Thank you. Right, before we proceed, as you can see, there are cameras that are set up in the courtroom. Indeed, the court earlier interacted with the state, the defense, as well as the members of the media, several media houses. And it was indicated that there is no objection to the broadcasting of these proceedings. The court, however, therefore makes the following order in order to make sure that we are all on par, and also that the following order is going to be observed. Firstly, the broadcasting and or live streaming of the proceedings is permitted, subject to the following conditions. The first condition, the presiding officer retains full discretion to regulate the broadcasting of the proceedings at any stage. Secondly, no interference with the dignity, decorum, or proper functioning of the court shall be permitted. Thirdly, the court may impose limitations on the broadcasting of certain witnesses or evidence where it is necessary to protect fair trial rights. Fourthly, the media houses shall comply with all directives issued by this court relating to the manner and scope of broadcasting, meaning that everything that will be done in an orderly fashion. Already the state, that is the prosecutor, as well as the defense, have requested and we agreed that their faces are not going to be shown. We will therefore proceed.
Inkantolo yachaza ukuthi babe nomhlangano umshushisi naye umeleli wakho naba bezindaba noma ukushashalaza ukuthi kunemithetho kumele bayisalemuka ukuthi icala lakho bazoqhubeka ngayo. Uyasho ukuthi imithetho elandelayo ukuthi bavumelane ngokuthi abayoveza ubuso kwinkantolo futhi abayoveza nobuso bakaMshushisi, futhi akuyoba nokuphazanyiswa okubakhona ngaphakathi kwenhambiso yesicelo sakho sayi-bail, futhi bayacela ukuthi abashashalazi nabo balandele yonke imithetho njengoba isho enkantolo.
Right, then, defense can proceed as you bear the honors of court.
As the court pleases, Your Worship. Your Worship, the defense will proceed by way of affidavit, and that affidavit has been provided to the state. For the easy reference of the court, if I may hand out the original signed affidavit so that the court can be able to follow the proceedings. With your leave, Your Worship, if I may proceed.
Yes, you may proceed.
Thank you. In the Magistrate Court for the Regional Division of Tshwane, held at Pretoria North, case number B300 of 2026, in the matter between Fannie Nkosi, Fannie Ezekiel, who is the applicant, and the state, who is the respondent. This is a statement that is prepared in terms of the provisions of Section 6011 of the Criminal Procedure Act 51 of 1977. I, the unassigned Nkosi Fannie Ezekiel, do hereby make oath and state that I am an adult male, South African citizen, born on 11th of September 1982, with identity number 820911576680. I am the applicant in this application, in which I seek from this honorable court to be released on bail. I respectfully submit, as I will demonstrate herein, that the interests of justice permit my release on bail. In any event, the dictates of fairness and justice, in view of peculiar facts herein, warrant that I should not be deprived of my liberty, and that I should be released on bail. I make this affidavit on my own free will and have not in any way been unduly influenced to depose thereto. The facts herein contained, save where expressly indicated to the contrary, are within my personal knowledge and belief are both true and correct. Charges against me. I have been informed of all the charges against me, of defeating the ends of justice, theft, possession of unlicensed of ammunition, and possession of stun grenade, and I will be pleading not guilty on the charges against me. At the provisions of Section 6011 of Act 51 of 1977. The purpose of this affidavit is to provide the above honorable court with my personal circumstances and to address the allegations leveled against me insofar as they are known to me, as well as to address the factors to be considered by the above honorable court as contained in Section 64 to Section 69 of the Criminal Procedure Act 51 of 1977. I have been advised and I understand that I bear the burden to show that the interests of justice permit my release on bail and that I'm obliged to initiate this application. I fail to understand how I could be charged with defeating the ends of justice, theft, possession of unlicensed ammunition, and possession of stun grenade, as was indicated to me at Pretoria North Police Station by the investigating officer and various the warrant of search and seizure, and eventually my arrest and detention, as I did not commit any of these offenses. However, I will put factors before the above honorable court to show that it is in the interests of justice to permit my release on bail. I contend that the state and prosecution will not be able to present any objective facts that I committed the defeating ends of justice, theft, possession of unlicensed ammunition, and the possession of stun grenade, as these charges are merely fabricated against me. At the applicant's personal circumstances. I am an adult male employed as a sergeant at South African Police Services, and I reside at House 67, Pankata Street, Dorandia, Pretoria North, Gauteng Province. I was born on the 11th of September 1982 in the Republic of South Africa, and I have resided in the Republic of South Africa all my life. Although I have traveled overseas on holiday, I regard South Africa as a permanent place of abode, and I have no intentions to relocate to another country as I love my country. I am married in community of property to Elizabeth Ndombizodwa Nkosi, who was born on 15 May 1981 with identity number 810515070888. And my wife and I have a child that was born out of our marriage relationship, namely Ndumiso Sibonelo Nkosi, who was born on the 3rd of January 2018 with identity number 1801035939-081. I confirm that I do not have any relatives outside the Republic of South Africa, nor I have business or assets outside the Republic of South Africa, and I do not conduct business outside the Republic of South Africa, and I am not a flight risk. My wife and I jointly own immovable assets in the Republic of South Africa within the above honorable court's jurisdiction, which is the following: the immovable property in which I currently reside at number 67 Panchata Road, Utorandia, Pretoria North, the property in Gauteng province, and it is encumbered by a mortgage bond in the amount of approximately 1,500,000 rand, and I'm currently paying a mortgage bond of 7,500 per month on monthly basis. I own immovable assets comprised of household furniture and effects and a motor vehicle, which are valued in excess of 500,000 rand. My friends and family reside in the Republic of South Africa. My professional occupation currently provides me with a monthly income of 16,500 rand. I've never been convicted of any criminal offences either in the Republic of South Africa or elsewhere. There are no outstanding cases other than the present being investigated against me by the members of South African Police Services. At the merits of the charges against the applicant, my legal representatives have explained that the provision of Section 611 of the Criminal Procedure Act 51 of 1977, and I respectfully make the following submissions in this regard. I have been informed that I'm accused of having committed the offences of defeating the ends of justice, theft, contravention of Firearm Act, possession of unlicensed ammunition, and possession of stun grenades, and I deny the aforesaid allegations in the strongest terms. I am advised that I do not have to deal with the merits of the case for the purposes of the bail application. However, I believe that it is appropriate to deal with the merits in this application, particularly in view of how the state portrays the charges against me. I will deal with the allegations leveled against me by the state insofar as they are known to me, and demonstrate to the above honorable court that the charges against me have been fabricated and made in order to frustrate me and place me in hardship as far as the issues pertaining to the internal disciplinary hearing against me and what has transpired in Madlanga Commission. The state has charged me with the contravention of Section 120, subsection 8A of the Firearms Control Act 60 of 2000, in that I failed to lock away my firearms in a prescribed safe, strong room, or device for safekeeping when those firearms were not in my possession or control, and I deny these allegations in the strongest terms. The firearms that were taken by the police who came and searched my house on the search warrant are all licensed firearms, and I was issued with a license and or permit to be in lawful possession of those firearms. On 2nd April 2026, the members of South African Police Services under the National Task Team came to my property and presented me with a search warrant which authorized them to search and seize firearms, ammunition, firearm licenses, permits or authorizations, safes and firearm storage facilities, and any documentation relating to the possession, storage or control of firearms. Upon their arrival, the members of South African Police Services under National Task Team filled with the cameras in my property, and as a result, at the time when they were in my property, the cameras were not working as they had switched them off. The members of South African Police Services under National Task Team
switch off your cell phones, put it on silent for the last.
Any police phone who's going to ring again, that person is going to be held in contempt of court. All cell phones have to be switched off now. If you didn't switch it off earlier, switch it off now. From now on, if your phone rings, the police is going to hold you in contempt.
As a court, Your Worship. The members of South African Police Service and a National Task Team requested that I direct them to the safe where I keep my firearms and ammunition. And I directed them to the safe that is mounted in the wall in my house, and they found 7 firearms and ammunition that I have licenses and permits to keep them. I deny that I have contravened the Section 120, subsection 8A of the Firearms Control Act 60 of 2000, as all the firearms and ammunition that was in my possession was in the safe, which is mounted in the wall for safekeeping in terms of the Act 60 of 2000. And the safe where the firearms were found is not easily removable as alleged by the state. And during trial, the state will not be able to prove this offense. I deny in stronger terms that there were firearms that were found under a mattress, under the bed, and in the motor vehicle, as all the firearms that were taken by the members of South African Police Services were all in the safe that is mounted in the wall of my house in terms of Section 120, subsection A of Act 60 of 2000. I condemn that the state's case is weak and non-existent, as I did not contravene Section 128A of Act 60 of 2000, and this charge is brought in order to frustrate me. The state and prosecution also charged me with defeating the ends of justice and obstruction of justice, in that I was found in possession of the state-issued ammunition while I am on suspension. I am advised that the offense of defeating and obstruction of justice consists of unlawfully and intentionally engaging in conduct which defeats, obstructs the cause or administration of justice. I wish to place it on record that on 28 March 2026, I was suspended as provided in Regulation 5.4X as envisaged in the South African Police Service Discipline Regulations number R1361 of 1 November 2026. Regulation 5.4X of the South African Police Service Discipline Regulations of number R1361 of 1 November 2016 stipulates that the following terms of misconduct may warrant the institution of expeditious procedure as provided in Regulation 9X. Any act or misconduct which detrimentally affects the image of service or brings the service into disrepute or which involves the element of dishonest. The South African Police Service Discipline Regulation number R1361 of 1 November 2016 does not provide that on suspension that I ought to bring all ammunition that was issued by the state to me. And the allegation that I defeated or obstructed the ends of justice is unwarranted, as I did not unlawfully and intentionally engage in conduct which defeats or obstructs the cause of administration of justice. During my suspension, I was never informed that I ought to bring all the ammunition that was issued to me by my employer, and the state and the prosecution seek to use the internal disciplinary process in order to achieve its ulterior motive, which is not premised on justice. I wish to indicate to the above oral court that I was officially suspended by my employer on 28 March 2026, which was on Saturday, and I immediately handed in my appointment certificate, access card, firearm, and the laptop that was issued to me by my employer. I was informed on the date of my suspension that I ought not to enter the premises of my employer and or communicate with the witnesses in the disciplinary proceedings. I contacted my attorneys who are advising me in the disciplinary hearing in Madlanga Commission, who advised me that I should wait for my employer to indicate the processes to follow, as I am not allowed to enter the premises of my employer, and my access card was taken. On 2nd April 2026, which is 4 days after my suspension, I was arrested for the charges that I'm facing, and it is my contention that I did not defeat and or obstruct the ends of justice, as I could not have taken the ammunition to my employer, in contravention of my suspension terms, and these charges have no merits as the disciplinary code of my employer does not provide for such. The condition that upon my suspension I ought to have handed the ammunition to my employer is, I think it was supposed to be unwarranted, Your Worship, as the disciplinary code and the standing and order. I contend the state and the prosecution will not succeed in proving this case, and the state case is weak and non-existent against me. The state and the prosecution also charged me with the theft of documents that were found in my possession, and the state or prosecution alleges that the documents are undetected. I wish not to go into detail in regard to these documents, as this matter involves a matter of police intelligence. Besides, to state that I am a police officer and I work with documents, and the President of the Republic of South Africa, together with the National Commissioner, had established a task team to deal with cash in transit heist and violent crimes in South Africa, which is responsible to support the local police stations in regard to cash in transit and violent crimes. And the documents were in my possession as I am part of the team, as I am employed by the National Office for Organized Crime. At the time when I was suspended, these documents were in my possession, and as such I did not steal them, or I was not defeating the ends of justice. I wish to state that the state and or prosecution has no case against me, or is weak or non-existent, and this is the plot to victimize me. The state and or prosecution also charged me with the possession of stun grenade, and I dispute that the police who came to my house found a stun grenade, and this charge is fabricated against me. I contend that the state and the prosecution will not be able to prove this charge against me. The state or prosecution case is non-existent and weak against me. I wish to place it on record that in October 2025, the same members of South African Police Services who were working under political killing task team are the same members of the South African Police Services who are working under national task team, and they searched my house in 2025 without the warrant of arrest. At the time when they searched my house in October 2025, I was in possession of the firearms that I am charged with, and those firearms were kept in the same safe that were in when I was arrested. And this safe is mounted in the wall of my house, and this matter is brought against me as a result of the testimony that I gave in the Madlanga Commission. At flight risk, I will stand my trial. I will stand my trial should it proceed against me. I now have become a well-known sergeant in the South African Police Services. There is no possibility that I will even think of not standing my trial should there be one. I trust the South African legal system, and that the facts will show that I did not commit the offences that I have been charged with by the state and or prosecution. In order to persuade the above court that I should be released on bail, I provide the following additional facts and information in terms of Section 60 that need to be considered by this court in this application. At Section 60, subsection 4A, read with Section 60, subsection 5 of Act 51 of 1977. I do not know the identity of any witnesses upon whom the state will rely in order to attempt to prove a case against me, besides the police officers who were present during my arrest and executed the search warrant in my property. In any event, I have no intention to interfere with any witnesses, as I have no cause to do so, and I undertake not to do so. I contend that there is no likelihood that if I'm released on bail, I will endanger the safety of the public, any person in which the offense was allegedly committed against, or a particular person, or that I will commit a Schedule 1 offense. I contend that the witnesses in this case will in all probability be the police officers, and there is no evidence that if I'm released on bail, I will endanger the safety of the public or any person, as the charges that I'm charged with are offenses against the state and not a particular person. And as indicated, I do not have pending cases against me. Besides this case, no previous convictions. and outstanding warrants of arrest. And as such, there is no likelihood that if I'm released on bail, I will commit a Schedule 1 offense. I contend that no violence was used in the commission of the alleged offenses, which offenses are disputed. I have no resentment against my colleagues who arrested me. There is no evidence that I have disposition to commit the Schedule 1 offense, and in the past that I committed an offense referred in Schedule 1. I maintain good relationships with people and I bear no grudges against anyone. As previously stated, I have no previous convictions and I have not been released on bail pending any charges. I am not disposed to violence. At the provisions of Section 60, subsection 4b, we read with Section 60, subsection 6 of Act 51 of 1977. I respectfully submit that the facts set out above support my contention that I do not constitute flight risk. I contend that there is no evidence that if I'm released on bail, there is a likelihood that I will attempt to evade the trial. I'm gainfully employed by South African Police Services. I have immovable property within this honorable court's jurisdiction. My wife is gainfully employed as a traffic officer within this court's jurisdiction, and I reside with my family in this court's jurisdiction. As such, I will not benefit anything by evading my trial. It is my condition that I have emotional, family, and official ties to the jurisdiction of the above court where the charges against me will be tried, and as such, I will not evade trial. My passports are with the investigating officer of this matter against me, and as such, I have no means to leave the Republic of South Africa. And besides, now I am now known, and there is no way that I can leave this country by either road, sea, and or air. I cannot afford to forfeit any amount of bail money that can be fixed by the above honorable court, and the strength of the state's case is weak against me, and considering the charges against me, there is no gravity as no violence was used against any individual. I condemn that the prescribed sentence that this court may impose if I were to be found guilty in terms of the Act 60 of 2000 is 5 years, and as such the sentence is not grave to warrant that I flee and leave my family, employment, and immovable property behind. I have 2 South African passports. The one passport is my personal passport, and the other one was the passport that I was instructed to make for the official trip as a member of South African Police Services that I had to make to Italy, which did not materialize as the trip was cancelled. I only left the Republic of South Africa in 2012 when I went to visit Botswana, and I have never left South Africa again since 2012, and I'm willing to hand all my passports to the investigating officer, and I undertake not to apply for any travel documents. I condemn that there is no evidence that if I were to be released on bail, that I will evade trial. However, the facts that I have pointed out are indicative that I will stand trial should I be released on bail. My family and friends will be able to raise an appropriate amount to post as a bail. At provision of Section 60, subsection 4C, read with Section 60, subsection 7 of Act 51 of 1977. I have no knowledge of any evidential material which may exist with regard to the allegation leveled against me. In any event, I believe that whatever such evidence may be, it is in the possession of police in the South African Police Services, and it is safely secured, and I do not have access thereto, and I undertake not to interfere with any further investigations. I contend that the main witnesses in this case are police officers, and the evidence that will be used against is in the safety custody of police officers, and as such, if I were to be released on bail, there is no likelihood, Your Worship, that there's no likelihood that I will attempt to influence or intimidate these witnesses, or to conceal or destroy evidence that the state will rely on in an attempt to prove the charges that I have been charged with. I'm not familiar with the police officers whom I believe will be the witnesses in this case, and I believe they have already made the statements, and as such, there is no evidence that I will attempt to influence them. I believe that the bail conditions that will be imposed by this honorable court will be effective and enforceable in prohibiting communication between me and witnesses, and I undertake not to communicate with them. I am not sure which witnesses the state will rely upon in order to attempt to prove this case against me. Nonetheless, I undertake not to communicate with any witnesses, whoever he or she may be, and any other persons whose names may appear on the list of state witnesses to be provided by the state. My continued incarceration can only prejudice me and creates no benefit to the state. At the provision of Section 60, subsection 4D, read with Section 68 of Act 51 of 1977. This is my first arrest. I do not have any pending criminal cases against me, besides the charges that I've been charged with by the state and the prosecution. I contend that if I'm released on bail, I will not undermine or jeopardize the objectives and the proper functioning of the criminal justice system, including the bail system, as I have never been released on bail and undermine the criminal justice system and or bail system. I have never failed to comply with bail conditions previously, as there is no evidence that if I'm released on bail by this honorable court, I will not comply with any bail conditions that may be imposed by the above honorable court. At the provisions of Section 60, subsection 4E, read with Section 60, subsection 8, capital A of Act 51 of 1977. I respectfully submit that should I be released on bail, my release shall not disturb the public order or undermine the proper functioning of the criminal justice system. The offences that I have been charged with are the offences against the state, and as I have demonstrated, the charges against me are weak and non-existent, and are only brought against me in order to frustrate me for the reasons that are unknown to me. I will comply with such conditions as the above honorable court may wish to impose. I accordingly submit that the interests of justice, considerations of prejudice, and the balancing of respective interests favor my release on bail. My family and friends have advised me that they will be able to post bail in the amount of 10,000 rand. Signed and commissioned today, Your Worship, the 13th of April 2026. It has been duly signed by Mr. Nkosi. With your permission, my lady, may I hand up the affidavit as an exhibit?
Right, I noted that they were titled paragraph 45 and paragraph 21
It's the original, Your Worship. If I may just make the accused may make the necessary amendment. If I might turn my back, Your Worship.
Yes, ma'am.
Your Worship, if may assist, the other paragraph is 20.
21.21, the last line. You must page over on the last line of that paragraph. At least that's what you said. You told me it is a typo.
As a court resolution, may I hand the amended affidavit here?
Right, Counsel, before you rest, for the record, I see previously when my sister presided, Ms. Fender, it was indicated that your client speaks Zulu, right?
That's correct, Your Worship.
Does he require the services of an interpreter to interpret the contents of this affidavit?
If I may inquire, Your Worship.
Yes, you may approach.
He indicates that he understands, Your Worship.
All right, please stand up, Mr. Nkosi. Do you confirm the contents of this affidavit?
Yes, I confirm, Your Worship.
The signature attached on the second last page of this affidavit above the names Nkosi, Fannie, Ezekiel, you confirm if it's your signature?
Yes, I confirm, Your Worship.
And I see there's also initialing on each and every page. Do you confirm that you've initialed all the pages of the affidavit?
Yes, I confirm, Your Worship.
Right, you also confirm its contents.
That's correct.
Thank you. Right, State, do you have any objection that this affidavit be accepted as evidence?
No objection, Your Worship.
All right. An affidavit in support of the applicant's formal bail application is accepted as evidence. It is marked Exhibit A. Yes, please.
As a court pleases, Your Worship, that is the case for the applicant.
Thank you. Yes, State.
And the court, please, Your Worship. Your Worship, we only received the affidavit this morning when the court started. Therefore, the state requests a matter to stand down until 12 o'clock just to respond to the allegations made in the affidavit.
So you'll be ready at 12 o'clock?
Yes, yes.
I can just walk in.
No, Your Worship will call you at working day around that time. It could be before that.
Okay, you can communicate with my administrator.
Thank you, Your Worship.
Ms. Antonia, can I please have the card? We adjourn until just after 12 o'clock. Apologies.
All rise, please stand. Please be seated.
She's busy finalizing the reply.
All right. Let's get the accused person in the dock so that he hears for himself. Please
Oh,
call
there's
him.
a court basis.
Please call Mr.
Mr.
Nkosi.
Nkosi? Please stand in front of the microphone, sir.
It's okay. You don't have to repeat.
Okay, thank you.
Mr. Nkosi, I'm told that the state is still preparing to reply. They are delaying. I received a message from my personal assistant who received the message from the state. Where is the legal representative?
I'm here, Your Worship.
Yes.
I-
Yes, before I allow you to respond, Advocate, what time are you going to be ready?
Your Worship, the request I received from my colleague is that they will be ready by 2 o'clock.
Yes.
Your Worship, I don't know what to say because when we postponed this matter last week on Tuesday, they indicated to the court that they want the matter to be postponed for bail application. They're opposing the release of Mr. Nkosi on bail. So they knew why they were opposing the release of Mr. Nkosi on bail on Tuesday. And if there are issues that came up now during this application and they want to supplement their reasons for opposing the bail, I don't think it will take more than 2 hours. We are adjourned at 11 o'clock, Your Worship. Now we're going to come back at 2 o'clock and we are adjourned at 11 o'clock. When we want to reply to the things that we've raised, because the things that we've raised, I think is only the issue of merits, but the other issues are standard when it comes to bail application. So they knew. So if they wanted to edit them, to edit something on something that we've already typed, it will not take 3 hours, Your Worship. And it's 2 o'clock, and then I don't know when we will finish. And the bail application is urgent in its nature. That Mr. Nkosi has been in custody for over a week now, and for flimsy reasons, Your Worship, with respect, as a court presence.
I hear you. Before I give a ruling, do you want to say something, Advocate Mpatlela? I saw you were halfway up.
Your Worship, I'm tempted to reply to what my learned colleague has said. I was not part of the proceedings last week, but I was here. Fortunately, when he was addressing the court, I had arrived in court. And safe to say, what he says or the submissions that he's making now, it's unfortunate because 1 o'clock to 2 o'clock is lunchtime. And we only got the affidavit when we walked into court. I asked him, do you mind giving us the affidavit so that we can make copies and go through it? Unfortunately, we only got the affidavit when Your Worship was walking into court. When we left the office, Your Worship, after that small meeting in chambers, that's when I got the affidavit from my colleague. And it was because I asked for it.
All right.
I anticipated this kind of a situation because we did not anticipate the things that they said in the affidavit, which we don't agree with.
Thank you. Let us not waste any time any further. I will allow the state, in the interest of fairness, to get their house in order. Will you be ready by 2 o'clock?
We will be ready.
Okay. I am going to walk in at 2 o'clock. I won't wait for anyone to call me or anybody to do anything else. 2 o'clock exactly, I'm going to walk in. We are going to proceed.
We promise you.
Thank you.
That's
Could I just?
All right, please stand. Please be seated for we'll resume at 2 o'clock. Mr. Nkosi.
Isuna, I still meet your
Be seated.
Please be seated. Your cell phones on silent. Switch off.
Let's go back on record.
Thank you, Your Worship. On resumption of case number B 300/2026, appearances are as before. Your Worship, the state is ready to proceed, and the state is in possession of the affidavit in opposition of bail.
All right, please call the accused first, ma'am.
Oh, yes. Thank you. Your Worship, the state is ready to proceed, and the state is in possession of the affidavit which was compiled by the investigating officer in this matter. Your Worship, I'd like to hand the copy to the court for the court to follow. This is the original, actually not a copy. Thank you. It's the statement together with annexures.
Have you also provided same to the defense?
Yes, Your Worship, I have provided same to the defense.
You confirm same?
I confirm, Your Worship.
Thank you. Yes, you may proceed.
Thank you, Your Worship. Affidavit in opposition of bail application, Pretoria North, case 17/4/2026. In the Magistrate Court for the District of Tshwane, held at Pretoria North Magistrate Court. Case number 300 of 2026, in the matter of Fannie Nkosi, the applicant and the state. Affidavit in opposition of bail application. I, the undersigned Tembekile Madwa, hereby make oath and state that I am in the service of the state, a sergeant with service number 213390007 in the South African Police Service, hereinafter referred to as SABC, attached to the National Task Team investigating recommendation made by Madlanga Commission of Inquiry. My work address and offices are situated at 231 Francis Bart Street, Pretoria Central. And I am contactable on the following cell numbers. I will not read them out, Your Worship. My email address is madot3@sabs.gov.za. The facts contained in this affidavit fall within my personal knowledge, paragraph 2, unless otherwise indicated or unless the contrary appears from the context, are, to the best of my belief, true and correct. I gained knowledge of the facts stated in this affidavit through personal observations, as well as from records of a continuous nature received in the performance of my duties to record information supplied by others who had or may reasonably have personal knowledge of those matters. Paragraph 3, introduction. I have been appointed as a member of the South African Police Service in terms of Section 30 of the SAPS Act 108 of 1995. I perform my duties in terms of Section 13 of the SAPS Act 68 of 1995, read with Section 205 of the Constitution of the Republic of South Africa, Act 108 of 1996. I am the investigating officer in this criminal case with the following details. Pretoria North, case 17/4/2026. The charges against the applicant are as follows. 4.1, contravention of Section 6, read with Section 1, 7, and 10 of the Explosives Act 26 of 1956, further read with Section 51, subsection 2 of the Criminal Law Amendment Act 105 of 1997, unlawful possession of an explosive, and this is one count. Contravention of Section 120, subsection 8A, read with Sections 1, 117 of the Firearms Control Act 60 of 2000, also read with Regulation 86 of 2004, Firearms Control 2004, failure to fix safe to a wall or floor to safeguard firearms and ammunition, one count. 4.3, contravention of Section 120, subsection 8, read with Section 1, 117 of the Firearms Control Act 60 of 2000, also read with Regulation 86 of 2004, failure to safeguard firearms. to wit the following firearms: a .38 revolver, a Pietro Beretta 9mm pistol, and a radical rifle. There are therefore 3 counts. 4.4, contravention of section 120 subsection 8A, read with sections 117 of the Firearms Controls Act 60 of 2000, and also read with regulation 86 of 2004, failure to safeguard ammunition. There are 3 counts. Section 90, read with sections 103, 117, 121, A, 121, read with Schedule 4, and Section 151 of the Firearms Controls Act 60 of 2000, and further read with Sections 250 of the Criminal Procedure Act 51 of 1977, possession of ammunition, 2 counts. Contravention of Section 120, read with Sections 117 of the Firearms Control Act 60 of 2000, also read with Regulation 86 of 2004, failure to safeguard ammunition. 4.7, defeating and or obstructing the administration of justice. There are 4 counts. Theft, there are 5 counts. Acquisition, possession, or use of proceeds of unlawful activities in contravention of Section 6, read with Sections 1 and 8 of the Prevention of Organized Crime Act 121 of 1998 as amended. There are 2 counts. Paragraph 5, I am advised by the state prosecutor that the charges against the applicant in these proceedings fall within the ambit of Schedule 5 of the Criminal Procedure Act 51 of 1977 for the purpose of bail application. The reason is that the state alleges that the applicant was found in possession of an explosive device, a stun grenade, which falls under the Explosives Act 26 of 1956. The background: search and arrest. The accused was arrested following unlawful activities discovered during the execution of a search and seizure warrant, J51, at his residence. The search and seizure warrant was authorized by the magistrate at Pretoria North Magistrate Court on 1 April 2026. The search and seizure warrant, the J51, was executed on the 2nd of April 2026. Upon arrival at the residence of the applicant, upon the arrival at the residence of the applicant, signed the search and seizure warrant. The applicant signed the search and seizure warrant and gave the officers consent to search the premises as the order of the court. The search began at the main bedroom of the applicant. A rifle safe, which was not mounted on the wall or on the floor as prescribed by the Firearms Control Act 60 of 2000, was found, and therefore the applicant has contravened Section 120 subsection 1 with Section Regulation 86 subsection 1 of the Firearms Control Act 60 of 2000, which dictates that safe custody of firearms, that a safe must be permanently fixed to a wall or floor or both of a house, flat, or residence. Upon opening the unmounted safe, we discovered different types of calibers of firearms which are licensed to the applicant. AKM 7.62 by 39mm rifle, which is a replica of an AK-47 with serial number LE7827, and his license is valid from 5 January 2022 to 1 January 2032.
Till when?
4 January, sorry, Your Worship, 4 January 2032. B, an Orinco 9mm parabellum 9 by 19mm pistol with a serial number 47005765. The license is valid from 30 October 2024 to 29 October 2034. And C, shotgun 12GA serial number 628 H22YG/85. The license is valid from 11 September 2023 to 10 September 2033. A shotgun 12GA serial number 18E/1005, where the license is valid from 4 April 2019 to 3 April 2029. Paragraph 6.3. The following ammunition was also found inside the said unmounted safe: 35 AKM 7.62 by 39 mm rifle ammunition, 94 9mm live ammunition, 57 shotgun live ammunition, 101 5.56 by 45 mm live ammunition, 6 times 9 mm empty or fired cartridges. Inside the drawer of the headboard in the main bedroom, the following ammunition was found and collected: 16 9mm live ammunition, 6 5.56 by 45 mm live ammunition, 4 revolver live ammunition. There was cash consisting of 100 rands notes. The applicant has therefore contravened Section 120, subsection 1, read with Regulation 86, subsection 1 of the Firearms Control Act 60 of 2000, which prescribes that ammunition must be stored in a locked safe strong room or evidence that complies with South African Bureau of Standards, SABC standards. The drawer is not lockable. Under the mattress in the main bedroom, the following articles were found: a .38 revolver with serial number LJ 38437, loaded with 5 rounds of ammunition. The applicant has therefore contravened Section 8A. Your Worship, may it read Section 8A of the Firearms Control Act, failure to safeguard the firearm. The Act prescribes that a person is guilty of an offense if he or she fails to lock away his or her firearm in his or her possession in a prescribed safe, strong room or device for the safekeeping when such firearm is not carried on his or her person or is not under his or her control. The applicant also failed to produce the license of the firearm, indicating that it was somewhere in the house. The applicant further contravened Section 120, subsection 8A of the Act, which provides that the person is guilty of an offense if he or she fails to produce a license, permit, or authorization when lawfully required to do so by a police official. Under the same bed in the main bedroom, the following articles were found: a radical 5.56 by 45 mm rifle with the serial number 23/075853, where the license is valid from 13 August 2024 to 12 August 2034. The applicant has therefore contravened Section 8A of the Firearms Control Act, failure to safeguard a firearm. The Act prescribes that a person is guilty of an offense if he or she fails to lock away his or her firearm or a firearm in his possession in a prescribed safe, strong room or device for the safekeeping when such firearm is not carried on his or her person or is not under his or her direct control. There was also cash under the bed consisting of 200, 100, and 51 notes. The cash found under the bed was counted together with the one found in the drawer of the headboard in the presence of the applicant, and it amounted to 52,700 rands. Inside a white Volkswagen Passat motor vehicle, the registration number plate FG52PZGP belonging to the applicant parked at the premises, the following articles were found: a Pietro Beretta .40 S&W 9mm pistol with serial number A60651M, license valid from 13 November 2024 to 12 November 2034. The Pietro pistol contained 11 rounds of ammunition in the magazine and 1 round in the chamber. The applicant is therefore contravened Section 120, read with Regulation 86, 1 of the Firearms Control Act, failure to safeguard a firearm. The Act prescribes that a person is guilty of an offense if he or she fails to lock away his or her firearm in his or her possession in a prescribed safe, strong room or device for safekeeping when such a firearm is not carried on his or her person or is not under his or her direct control. In the same Volkswagen Passat motor vehicle, on the front passenger seat, there were 2 rifle magazines, both loaded with ammunition, 5.56 by 45 millimeters. 1 magazine with 29 live ammunition, of which 14 of those ammunition are police-issued ammunition, and the second magazine with 30 live ammunition, of which 5 of those ammunition are police-issued ammunition. There were 4 live rounds of revolver ammunition in the ashtray of the Volkswagen Passat motor vehicle. The applicant has therefore contravened Section 120, Regulation 86 of the Firearms Control Act, which prescribes that ammunition must be stored in a locked, safe, strong room or device that complies with SABC standards. A search was conducted at the Wendy House structure, which appeared to be used for storage of unwanted items for disposal, and the following exhibits were recovered. Original dockets. A. Ritgat Cas 671 of 1/2013, common robbery. On 29 January 2013 at about 10:30 a.m., an employee of British American Tobacco Company was driving a VW transporter delivering cigarettes valued at 44,000 rands at the tuck shop in town, when he was approached by 2 suspects instructing him to hand over the car keys. They took him with the vehicle to a secluded place where they loaded the cigarettes in a silver Opel Corsa. Inside the docket, there were fingerprints, SAPS 76 and SAPS 192, of one suspect who was charged, but the fingerprints were never submitted to the LCRC to be processed. The docket shows that the suspect made his first appearance on 7 September 2016, and the matter was postponed to 13 September 2016 for attorney. The suspect was never charged on the system. No further updates were available on the docket. Sinoville Cas 585 of 1/2014, car hijacking. On 31 January 2014, at about 8:15 a.m., an employee of British American Tobacco Company was driving a VW Caddy when he was stopped by suspects who were driving a Kumbi. The suspects forced him to the bush, where the cigarettes valued at 298,000 were loaded into the Kombi, and they left him with a VW Caddy. The Fidelity Security Services indicated that they can provide the CCTV footage on the VW Caddy to assist with the investigations, and arranged that the British American Tobacco employees for ID parades. No further investigation was conducted. C. Attridgeville Cas 11 of 10/2015, car hijacking. On 1 October 2015 at about 10 a.m., an employee of British American Tobacco Company was driving a Caddy when he was hijacked while carrying stock of cigarettes. The employee managed to press the panic button, and therefore the suspects dropped him at Lotus Gardens with the said VW Caddy, but took his personal belongings. The fingerprints of the suspects were lifted. CCTV footage installed in the Caddy was downloaded, and footage depicting the suspect was filed in the docket. No further investigation was conducted. Soshanguve, Cas 311 of 7/2019, accessing or intercepting data without authority or permission. On 27 June 2019 at 18:27 p.m., Umashi Samson Dlamini, employed by the City of Tshwane Metro Police Department as Deputy Chief of Police, stated that he received messages from people on his contact list that they received Christmas wish messages from his cell phone. He has suspected that his cell phone was backed and therefore registered a case. The applicant applied for a Section 205 of the complainant from the service provider, Vodacom. No further investigation was conducted. The applicant was given an opportunity to return all state property during the notice of his suspension from the South African Police Service, and yet he opted to retain some of the state property. Therefore, his conduct amounts to defeating the ends of justice. Docket copies found in the Wendy House. Rutherford Cas 26 of 6/2022, cash in transit. On 1 June 2022 at about 10:30, an employee of G4S Security, was collecting money at Westgate Mall when he was approached by two suspects who pointed him with a firearm and took his company pistol and cash valued at 620,000. The firearm of his crew member was also taken. No further investigation was conducted. Seriana Khain 651 of 3/2014 attempted car hijacking and robbery of a police firearm and cell phone. On 29 March 2014 at about 12:30, a police officer, LCRC member, was driving an unmarked police vehicle towards his homestead when he was blocked by two vehicles and the suspects robbed him, the state vehicle, firearm and cell phone. The suspects realized that it was a police vehicle and dumped it a few kilometers from the scene of the crime, but took the service pistol and cell phone. No further investigation was conducted. The applicant was given an opportunity to return all state property during notice of his suspension from the South African Police Service, and yet he opted to retain some of the state property. Therefore, his conduct amounts to defeating the ends of justice. Other exhibits found in the Wendy House. Mosina, case number 203 of 9/2022, a forensic science laboratory report from images analysis subsection regarding the enhancement of CCTV footage of the cash in transit crime scene which occurred at Mosina, showing the suspects and vehicles used by the suspects during the commission of the offense. The applicant was given the opportunity to return all state property during the notice of a suspension from the South African Police Service, and yet he opted to retain some of the state property. Therefore, his conduct amounts to defeating the ends of justice. Department of Correctional Services, an original internal disciplinary hearing document marked confidential, which contains the investigation conducted about the officer of correctional services who was responsible for the parole of one of the suspects arrested at Mosina for cash in transit. Mosina case 203 of 9/2022, and unlawful possession of firearm cases, Mosina case 210 of 9/2022. The officer indicated that the suspect has signed for his parole, whereas the suspect was in custody for the Mosina cases. The DCS internal disciplinary document containing personal particulars of the witnesses who disposed statements for the disciplinary hearing of the officer. The applicant has contravened Section 100 of the Protection of Personal Information Act, POPIA, Act 4 of 2013, in that he was in possession of confidential documents which has the personal information of other people without authority. CCTV footage for Harankua case 79 of 7/2014, car hijacking. The CCTV footage containing the pictures of the suspects who were involved in robbing the VW caddy of the British American Tobacco Company. The applicant's conduct amounts to defeating the ends of justice. During the continued search of the premises, we proceeded to a lapa structure situated within the dwelling of the applicant. Inside the said structure, we discovered the following items: 18 9mm live ammunition, 10 5.56 by 45mm rifle ammunition, 2 shotgun live rounds ammunition. The applicant has therefore contravened Section 120, read with Regulation 86, subsection 1 of the Firearms Control Act 60 of 2000, which prescribes that ammunition must be stored in a locked safe, strong room, or device that complies with SABC standards. D, an explosive to it, a stun grenade. The Inspector of Explosives, Warrant Officer Mate, attached to the explosive section, Bomb Disposal Management, has tested the exhibit, the stun grenade, and found it functional. He has deposed an affidavit to that effect. The applicant has therefore contravened Section 6, read with Section 1, 7, 10, and 10 of the Explosive Act 26 of 1956, which indicates that a person found in unlawful possession of a stun grenade may be found guilty of an offense which carries a maximum term of imprisonment of 15 years. SAPS leg irons. According to the SAPS 108 inventory, The leg IOs were never issued to the applicant. The applicant was given an opportunity to return all state property to the notice of his suspension from the South African Police Service, and yet he opted to retain some of the state property. Therefore, his conduct amounts to theft of state property. It is worth mentioning that amongst the ammunition found in possession of the applicant, there was also state-issued ammunition, which are unique to the police and identified with P at the back of the ammunition. The following ammunition of the state was found: 44 times 9 state-issued ammunition, 42 times 5 R5 state-issued ammunition. The applicant was given an opportunity to return all stolen property during the notice of his suspension from the South African Police Service, yet he opted to retain state ammunition, which amounts to theft of state property. The total ammunition recovered during the search in total is 490 and are broken down as follows. Pistol 9mm, there were 202 live rounds. Rifle R5, 183 live rounds. AK-47, 30 live rounds. Shotgun, 65 live rounds. Large amounts of cash. During the search and seizure operation conducted in terms of the Crime Asylums Act 19 of 2020 at the applicant's residence on 8 October 2025, police members from KwaZulu-Natal attached to the Serious and Violent Crime Unit recovered an amount of 385,070 rands in cash, which was found inside a safe, and it was confiscated. On 2 April 2026, I executed the search and seizure operation at the applicant's residence. An additional 52,700 in cash was discovered hidden under the mattress and inside the drawer in the applicant's bedroom. The applicant has failed to provide any satisfactory explanation regarding the origin of these substantial amounts of cash. The applicant's known income as a member of the South African Police Service is significantly lower than the lifestyle he appears to maintain. These circumstances raise a reasonable suspicion that the funds may be proceeds of unlawful activities, that the applicant may be involved in money laundering activities, and as envisaged in Section 6 of POCA, Prevention of Organized Crime Act. Investigations conducted after the arrest. The applicant was at the time on suspension from the South African Police Service and therefore had no lawful reason to be in possession of police operational equipment and confidential investigative documents. The suspension letter, which was served to the applicant on 11 February 2026, is attached and marked as TM1. On 11 February 2026, Brigadier F. Rasan received inventory list of police issue of the applicant in terms of Section 108 of the Police Act, and the applicant submitted the state property in terms of the SAPS 108 inventory. The Brigadier's statement is attached to this affidavit and marked as TM2. The statement of Lieutenant Colonel Skosana of Support Services Supply Chain Management was obtained, which indicates that the applicant was issued with a police R5 rifle with 60 live ammunition. However, when the applicant returned the R5 rifle and ammunition, the applicant brought 72 live ammunition of R5, which means that there was an extra 12 rounds. It is further confirmed in the statement of the that the applicant was never issued with a stun grenade and SAPS leg irons. The applicant was therefore unlawfully in possession of the state ammunition and leg irons, which amounts to theft of state property. The applicant was also unlawfully in possession of the stun grenade. Investigations pertaining the docket recovered in possession of the applicant. The presence of police dockets and confidential investigative materials in possession of the applicant raises serious concerns regarding unauthorized access to sensitive information and potential interference with investigations. I provide an outline regarding police dockets and other investigative materials found in possession of the applicant. Atteridgeville, case 11 of 10/2015. Inside the docket, fingerprints lifted from the crime scene, CCTV footage disc found inside the docket, still photos created from the CCTV footage obtained at Fidelity Security Company, and a statement from Fidelity Security Company. According to the information from the police system, confirmed by the archive clerk at Atteridgeville SAPS, which is marked in the docket as A11, the applicant signed for this docket on 21 June 2016. He kept the original docket until the date 2 April 2026, when it was recovered during the search. A duplicate docket was therefore opened by Lieutenant Colonel Ramogoka and closed it in the system because the original docket was missing. There is no other reason for the applicant to keep this docket other than to frustrate the investigation and defeat the ends of justice. I am saying this because since the applicant signed for it at the station in 2016, no investigation was carried out by him. Instead, it was gathering dust at his house for the reasons known only by him until it was found on 2 April 2026. B. Soshanguve, case 311 of 7/2019. Accessing or intercepting data without authority or permission. The docket was registered at the station and transferred to head office. It was then acknowledged by Lieutenant Colonel Mojekwa, A12. According to A12, he does not recall signing or investigating such a docket. Between 2013 and 2022, he was working with files, not case dockets. He alleges that someone unlawfully used his credentials to acknowledge the docket. In the said docket, the applicant applied for Section 205 subpoena to obtain call data from cell phone providers. The station was visited and they indicated that the docket is still under investigation 7 years later. The conduct of the applicant amounts to defeating and or obstructing the course of justice. Sinoville, case 585 of 1/2014, car hijacking. After the police station discovered that the docket has gone missing, Lieutenant Colonel Ramogoka inquired from the applicant about this docket, as according to the system, it was signed to him on the 9th of April 2015. The applicant's response was that he did not know the whereabouts of the docket. Yet, the original docket was later found at his place during the search and seizure on 2 April 2026. Lieutenant Colonel Ramogoka had to open the duplicate docket and file it as undetected on 24 July 2018. One could then draw an inference that the conduct of the applicant in hiding the docket at his premises was again none other than to defeat and or obstruct the course of justice, as the docket had to be closed as undetected. The investigation was stalled or hindered by the applicant's intentional conduct of denying knowledge of the docket, whereas it was in his custody. Read part 671 of 1/2013, common robbery. CCTV footage, 2 discs. A covering letter written by the applicant applying for analysis of the footage and preparation of the album. SAPS 192 elimination fingerprints for Kahisho Shomwani, 2 sets. SAPS 192 elimination fingerprints for Skiso Mtembu, 2 sets. SAPS 76 for fingerprints of the suspect, Kahiso Joseph Shomwani, charged in the docket. The SAPS 76 for the fingerprints of the suspect were found in the docket, and they were never sent to LCRC for processing, according to the standing order. Suspect fingerprints, SAPS 76, are supposed to be taken to LCRC within 3 days after being obtained from the suspect. However, the applicant kept them at his place for 10 years without being sent to the LCRC. The last time the docket was before court was on 7 September 2016, and it was remanded to 13 September 2016 for the accused person's attorney. After the said last appearance, there is nowhere in the docket that shows what transpired or the outcome of the investigation. The last entry on the SAPS 5 diary was on 20 April 2015 by the applicant when he was acknowledging the receipt of the docket on the system and proceeding to the Forensic Science Laboratory FSL. Another disturbing part in the docket's front page is that it was closed as undetected on the system on 6 February 2013, yet the docket was in possession of the applicant with all the evidence as outlined above. It is surprising that on 28 July 2015, a Section 212 statement of a member analyzing the CCTV footage was obtained and filed in the docket, whereas the docket was already closed as undetected in 2013. The docket archive store was visited to trace the docket. The purpose of this visit was to get a paper trail on how the docket was taken out of the stores, as system indicates the docket is filed at archive store. The clerk searched for the docket, but it was not found. The registrar that controls the movement of the docket was also perused, and this docket was never signed out at the station of origin, which clearly indicated that the docket was taken from the station unlawfully. A statement from SAPS archives clerk was obtained stating that this docket was never signed out in any register or system at the police station, which is the standard procedure. Again, one could also draw another inference that for the applicant to be in possession of this docket was to defeat the ends of justice, as no investigation was done until the station closed it as undetected. Docket copies found in possession of the applicant. Royal Report 26 of 6, 2022, cash in transit. During the commission of these offenses, the two firearms were robbed from security guards. Varianacheng case 651 of 3, 2014, a hijacking. During the commission of the above offense, a police officer was robbed of his service pistol and cell phone. On 15 September 2022, there was a cash in transit robbery at Musina, and the firearms of security guards were robbed in Musina, case 203 of 9, 2022. On the very same day of the 15th of September, 3 suspects were later arrested for possession of firearms at Messina, case 210 of 9, 2022, and the security firearms which were robbed during the cash in transit were recovered. The applicant arrived at the police station while the docket was being registered and demanded the possession of unlicensed firearm docket to be transferred to his unit at head office. The applicant demanded the docket in the presence of DPCI Messina officials who already had a cash in transit robbery docket as per Messina 203 of 9, 2022. And he used his office's superiority to attain the possession of the docket. It must be noted that the normal practice is that the possession docket must have been married or consolidated with the robber or cash in transit docket. Furthermore, both matters must have been investigated by one unit, not separately, as it happened of the applicant's instance. The ballistic report of Messina case 210 of 9, 2022 was obtained, and it established that 2 of the recovered pistols were robbed from victims as per Varianacheng 651 of 3, 2014 and Royal Report case 26 of 6, 2022 respectively. After the applicant obtained the said ballistic report, he visited 2 police stations, being Varianacheng and Royal Report.
Is the recording machine still running, ma'am?
Yes, it is.
Thank you. You can carry on. Sarah.
Thank you, Ashik. After the applicant obtained the ballistic report, he visited the 2 police stations, being Varianacheng and Royal Report, and made copies of those dockets, which were eventually found in the applicant's house. The applicant was duty bound to charge the Messina suspect, who were found in possession of those firearms, but instead he intentionally turned a blind eye by keeping the evidence to himself. Investigation revealed that the fingerprints lifted on the scene of crime on Varianacheng 651 of 3, 2014 positively linked the suspect, who is also one of the suspects arrested at Messina case 203 of 10, 2022, cash in transit, and Messina 210 of 10, 2022, possession of unlicensed firearms. To further prove that this same suspect was involved in Pretoria North case 651 of 3/2014 of robbery, the victim's service pistol was found in his possession during his arrest in Musina. During further investigation, it emerged that on 14 June 2024, the applicant has handed in the exhibit at Brits LCRC 160 of 6/2024, marked Musina 210 of 9/2022, where he specifically requested that Warrant Officer Modau be the member to analyze those exhibits. The investigation at Brits has revealed that the applicant submitted the exhibits using Musina 210 of 9/2022, whereas the scene reported indicated it occurred at half the BS Sport Dam. The applicant has shielded serious criminals who are involved in violent crimes like cash in transit, robbery, and with aggravating circumstances, instead of bringing them to court to account for the alleged wrongdoing. It will be a serious miscarriage of justice to afford bail to this applicant. With this kind of character, as clearly demonstrated above, there is a real likelihood that the applicant will attempt to frustrate or interfere with investigations against him. The evidence demonstrates that the applicant is not working alone in defeating and obstructing the course of justice, but is assisted by other officers who are not suspended from the SAPS. Should he be released on bail, he will continue in defeating and obstructing the further investigation on this matter, this and other matters. The applicant is aware of the confidentiality of certain documents within SABC and how these documents should be handled, yet he possesses such documents with no specific reasons that one could think of other than to defeat and obstruct the course of justice. The only inference to be drawn from the conduct of the applicant is interference with the normal process of investigation with the aim to defeat or obstruct the course of justice. Other exhibits found in possession of the applicant: CCTV footage for Karankwe case 79 of 7/2014 carjacking. The applicant was found in possession of the exhibit in form of one CCTV footage disc, which was obtained from the crime scene. The original docket was filed at the station on 1 June 2018. The applicant was not supposed to be in possession of these exhibits. SAPS standard procedure is that all exhibits must be kept in the SAP 13 and not to be in the possession of any investigating officer. When the applicant returned the docket to the station, he was supposed to have returned it with all exhibits linked to this investigation. The state therefore alleges that the applicant was unlawfully in possession of the exhibits, which amounts to defeating and or obstructing the course of justice. Summary. I find it disturbing that the applicant was found with dockets and exhibits which were not supposed to be in his possession, as the system shows that those dockets were closed or filed at SAPS station's archives. The applicant was further asked by Lieutenant Colonel Ramapoka about certain dockets which has gone missing, and he denied having been in possession of such docket, which later during the search, the docket was found in his possession. The conduct of the applicant was very disturbing, especially being the person who ought to know what he was supposed to do with the state property and or equipment. The applicant was also found in possession of CCTV discs, which would have assisted in identifying and prosecuting suspects. However, due to the applicant's deliberate conduct, criminals were never identified and prosecuted. The disturbing part is that some of the dockets were even closed and filed without certain evidence, which was supposed to be disposed during the filing of the docket. I submit that the applicant stole those dockets from the stations where they belong. The applicant's commander issued a statement filed as per A17 in the docket, stating that she is not aware of the dockets mentioned above. The applicant has come to be known as someone who has a propensity of distributing confidential documents to private individuals with the purpose of defeating and or obstructing the course of justice. It has also been discovered that the applicant is very much connected with people in higher positions from different departments, including police generals. Therefore, it is easy for him to influence and to tamper with any investigations, as it was demonstrated by the confidential documents from the Department of Correctional Services which were found in his possession. the applicant is not a suitable candidate to be afforded bail, as he can use his influence in higher offices to get anything that he requires. It would not be in the interest of justice to release him on bail. He may easily interfere with investigations and or intimidate witnesses. Association with criminal networks. Information obtained during the investigation indicated that the applicant is allegedly associated with individuals linked to organized criminal activities. The information available suggests that the applicant is involved or associated with criminal networks who are allegedly involved in drug trafficking and cash-in-transit robberies. The circumstances surrounding the testimony during the Madlanga Commission of Inquiry indicate the existence of serious allegations regarding criminal syndicates that may have influence within state institutions and elements of the criminal justice system. Risk to the applicant. As a witness in the Madlanga Commission of Inquiry, the applicant successfully brought an application to have his testimony presented in her camera and his identity to be concealed. His identity as witness F was later divulged by the Deputy National Commissioner of Crime Detection, Lieutenant General Sibia, who is alleged to be his close associate. This is an indication that there was a likelihood that his life was in danger. In the event that the inmate feels unsafe at the correctional facility, the state is able to arrange for an inmate to be kept at a more secure place where the inmate will be safe. The state is of the view that should the applicant be released on bail, his safety cannot be guaranteed due to the sensitivity of information related to his testimony at the Madlanga Commission of Inquiry. The continued detention of the applicant may therefore serve to protect his personal safety while the investigation continues. Public safety concerns within the household. During the search of the applicant's residence, a loaded .38 special revolver was discovered hidden under the mattress in his bedroom, on top of which his 8-year-old son was sleeping. The firearm was not secured in a safe or lawful storage as required by the Firearms Control 60 of 2000. The applicant resides in the house together with his wife and the minor child of 8 years old. The presence of an unsecured loaded firearm within the household creates a potential risk to them, and it demonstrates reckless regard for safety and constitutes a serious public safety concern. Unlawful possession of state property. During the search of the applicant's residence, police discovered state ammunition, police operational equipment, and official dockets. The applicant was at the time under suspension from the South African Police Service and therefore had no local authority to possess such state property. The possession of police dockets and operational material outside official police systems raises concerns regarding possible misuse of official information for unlawful purposes. Such conduct undermines the integrity of police investigation and compromises the confidentiality of criminal cases. Grounds for appeasing bail in terms of Section 60, subsection 4. 16.1, endangerment of public safety. The applicant was found in possession of multiple firearms, large quantities of ammunition, and an explosive, which is prohibited by law. The unsafe storage of a loaded firearm in a household where a minor resides further demonstrates the danger associated with the applicant's conduct. The applicant has demonstrated that he has the capability to shield dangerous criminals who are involved in CITs and robberies with aggravated circumstances involving the use of dangerous weapons. The applicant failed to arrest and charge the suspects who were clearly linked to prior hijackings and are still not charged and posing danger to the safety of the public. There is a likelihood that should he be released on bail, he may commit Schedule 1 offenses. This is demonstrated by the events of October 2025 raid, where an amount of 385,070 rand was confiscated, and again on the recent search in April 2026, where an amount of 52,700 was found under the mattress and drawer of the applicant's bedroom. Likelihood of evading trial, section 60, subsection 4B. The seriousness of the charges and the potential for lengthy imprisonment, the minimum sentence of 15 years, create a strong incentive for the applicant to evade trial. The discovery of large amounts of unexplained cash suggests access to financial resources that could assist anybody in prosecution. Interference with witnesses or evidence. The applicant is a trained police official with knowledge of investigative procedures and access to police network. The discovery of police dockets and sensitive investigative material in his possession creates a reasonable apprehension that he may interfere with investigations or evidence. The applicant knows the identity of the witnesses, and there is a likelihood that he might interfere with them. The applicant has working relationship with numerous police officers who will be called as witnesses. Some of these members may be vulnerable to influence or intimidation due to the applicant's influence and experience. Tampering with police systems or exhibits. Due to his knowledge of police system and investigative processes, there is a reasonable concern that the applicant may attempt to interfere with evidence, police administrative systems, case dockets, or exhibits if released on bail. This is evidenced by the applicant's possession of Red-Card 671 of 1/2030 without evidence of having lawful custody of this docket. Inside the original docket, the SAPS 76 fingerprints of the suspect were not sent to LCRC. This amounts to defeating through tampering with evidence, undermining the criminal justice system, section 64D. The allegations against the applicant's associations with individuals linked to criminal syndicates raises concerns, serious concerns regarding is a police officer entrusted with enforcing the law. The seriousness of the allegations against him, including unlawful possession of firearms, ammunition, confidential police material, and suspected links to organized crime, has a direct impact on public confidence in law enforcement. It is public knowledge that the applicant is deeply implicated in serious acts of criminality in the Madlanga Commission of Inquiry, and the public outrage emanating therefrom cannot be overemphasized. In response to the allegations by the applicant, the P team did not have access to CCTV of his house. During the execution of the search and seizure, the applicant's legal representative, Mr. Mwato, arrived accompanied by the applicant's wife, and he was afforded the opportunity to consult. At no stage did the applicant complain of fiddling of cameras or about any irregular activity by the team. As far as the issue of the safe is concerned, the team found it not mounted to the wall or fixed to the floor. The firearms were found under the mattress and the bed. It is shocking that the applicant denies knowledge of the explosive or the stun grenade found at his premises. The 2 R5 magazines containing ammunition were found inside the applicant's VW Passat motor vehicle, lying on the front passenger seat. There was also a revolver live ammunition in the ashtray of the said vehicle. There are pictures which were taken by LCRC during the execution of the search to the effect. Copies are sketched as for photo 99, 100, 113, 114, 115, 116, 118, 121, 122, 169, 170, 271, 273, 274, 292, 294, 303, 304, 329, and 330, 611, and 612 of the LCRC photo album compiled by Warrant Officer Ndumiso. The applicant, upon his notice of suspension from work, handed back some of the ammunition and dockets on the 11th of February 2026, as reflected on the affidavit of Brigadier Rosan, who received the applicant's SAPS 108 state property on behalf of the employer. It is surprising, therefore, for the applicant to allege that he did not know that ammunition and dockets must be returned to the employer, whereas the notice of suspension is very clear that all state property must be returned to the employer. The applicant was officially suspended from work on the 28th of March, but still he never bothered to return the state property found in his possession. The applicant had ample opportunity between 11 February 2026 and 28 March 2026. The applicant further alleges that he has handed the passports to the investigating officer, but I deny receiving any passport from him or his legal representative. The applicant's affidavit is contradictory in that on paragraph 37, he indicated that his passports were in possession of the investigating officer, whereas on paragraph 41, the applicant indicated that he is willing to hand over all his passports to the investigating officer. I vehemently deny that any member of this current Madlanga Commission task team was part of the search and seizure that occurred at the applicant's residence on 8 October 2025, as alleged on paragraph 22 of his affidavit. See the attached copies of both search and seizure warrants. The Madlanga Commission task team was established on the 8th of February 2026. Conclusion. Having regards to the seriousness of the offenses, the danger posed to the public, the risk of interference with witnesses and investigations, the possibility of additional charges, and the applicant's alleged association with organized criminal networks, it is respectfully submitted that the interest of justice will not be served by granting bail to the applicant. I therefore respectfully request this honorable court to refuse bail and that the applicant remain in custody pending the finalization of the investigation and trial. This statement was signed on the 13th of April at 1320, and it was commissioned by Captain J. Kubai. Your Worship, the statement is accompanied by a photo, in fact it's not the complete photo album, but it is accompanied by the front page of a photo album together with photos which have been referred to in the statement. May this be marked as TM3, Your Worship.
I'm referring to only the affidavit as well as the attached photos
Yeah,
from TM2 onwards.
Your Worship, in fact, can the affidavit be marked as TM3?
I have Exhibit A. I'm going
Oh,
to mark it as Exhibit
okay.
B if I
Fine,
accept,
please. That's fine, Your Worship.
together with the photos.
Yes, together with the photos.
All right. Yes, defense. Any objection
Your-
to that?
None, Your Worship. I have no objection.
Right. Before I do that, advocate, please approach your client. Find out regarding the language issue if he needs Ms. Kosana to interpret the statement that was read into the record by the state, or if he understood the same way he said he understood when his was read into the record.
Where's the copy, please? You understand, Your Worship?
Right then, the affidavit as deposed to by the investigating officer Tembekile Mandwa, accepted as evidence. It is marked as Exhibit B. It is attached together with the photos as attached. I will just count the number of pages that are comprising of the photos together with the front page of the photos.
Your Worship, there was also a...
Wait, ma'am.
Okay.
I have to count.
Okay.
all in all, from the front page, defense, I'm referring to this front page of the photo.
Yes, Your Worship.
State, can you see which page I'm referring to? This front page of the photo. This one. Then the next page is the first picture.
Can I please have a look at the page you're referring to?
Yes. You can also show to the defense what exhibit B is going to look like. It is the affidavit. I'm not giving you the affidavit. You already know. I'm referring to the attachment, that is the pictures. You can show to the defense as well.
Huh? No, it goes with the suspension. Okay.
Can I have the pictures back? Ma'am, please give me back the pictures. This is not what I
Sorry,
think.
here's yours, Your Worship. Here are the pictures.
I see the first page that was attached to the pictures. Is it an affidavit that you are still going to read into the record?
Your Worship, can you just have a short?
I'm not adjourning.
Not adjourning, just
I'm not
2
adjourning.
minutes.
I have 12 pictures here.
Yes.
I'm leaving that affidavit. I believe it's with you now.
Yes,
You
it's
didn't
with me.
return it. What I'm saying is I'm admitting Exhibit B. Exhibit B will comprise of the affidavit itself,
Yes, Your Worship.
together with the pictures. I have 12 pages of the pictures. Do you have same, Advocate?
Yes, Your Worship.
12 pages of the pictures plus the affidavit.
Yes, Your Worship.
That is what Exhibit B is going to comprise of.
As a court, please.
Thank you. Right, an affidavit by the investigating officer together with the pictures accepted as evidence. It is marked as Exhibit B. The affidavit itself comprises of 26 pages and the pictures are 12 pages. Exhibit B, that is. Yes, sir.
Your Worship, I don't know if it's opportune time to stand up at this time, just for the interest of justice and the assistance of the court.
Yes.
In the Exhibit B, the following affidavit, the deponent refers to Annexure TM1 and also TM2. I think for the interest of justice, they should be part of the affidavit because they are referred in the affidavit.
Yes. Where is TM1?
TM1 and TM2 is the ones you returned, Your Worship. That is TM1 and TM2.
Yes, that's what I was trying to ascertain from you.
Oh, okay.
All right. There's TM1 as well as TM2. Do you
Yes.
also want TM1 and TM2 to form part of the exhibits?
Yes, Your Worship.
Are you still going to read them into the record?
Yes, Your Worship.
Okay, let's deal with them. Let's deal with TM1 and then TM2. Let's move now. Time is of the essence.
Thank you, Your Worship.
What does TM1 say? Read it into the record.
Your Worship, I think I gave you my TM. Did I give you my TM1 by mistake?
I have an original. I
Oh,
didn't
okay.
take the TM1 and TM2. Start with TM1, read it into the record.
TM1 notice of suspension in terms, or it's written in Annexure E, South African Police Service, notice of suspension in terms of Regulation 10, subsection 3 of the South African Police Service Discipline Regulations 2016, parcel number 7135281-3, rank sergeant, name Fannie Nkosi. On 4 February 2026, you were afforded an opportunity to submit representations in response to a notice of intended suspension, which representations should have reached this office on 6 February 2026 at 12 o'clock. It is taken that you have decided to exercise your right by not making representations, and this has left the SAPS with no option but to take a decision without further notice. You are hereby notified that due consideration of the relevant facts and circumstances, I have decided to suspend you in terms of Regulation 10, subsection 3 of the South African Police Service Discipline Regulations 2016, with effect from 11 February 2026, as you have allegedly committed the following misconduct as provided in Regulation 5, subsection 3B, 1, Roman numeral 1, 2, and 3 of the South African Police Service Discipline Regulations 2016, in that you allegedly committed misconduct and performed an act or failed to perform an act with an intention to cause harm, to prejudice the interest of the service, be it financial or otherwise, undermine the policy of the service, not to comply with your duties and responsibilities, in that you had communication with key suspects who are implicated in serious criminal matters while investigations were underway by the South African Police Service, according to the evidence led at the Madlanga Commission of Inquiry over the period of 17 September 2025 to 28 November 2025. Your conduct revealed that you were part of a network of contacts which may have helped suspects get information or influence. As provided in Regulation 5.4 of the South African Police Service Discipline Regulations 2016, in that you allegedly committed misconduct, in that you performed any act of misconduct which detrimentally affects the image of the service or brings the service into disrepute, or which involves an element of dishonesty, in that during the proceedings at the Madlanga Commission of Inquiry, evidence was led over the period 17 September 2025 to 28 November 2025 that you may have functioned as an intermediary or candidate of a recipient of information that should not have been circulating outside local investigative channels. Your suspension will be subject to the following conditions. During your suspension, the powers and authority vested in you as an employee shall be held in abeyance, but you shall continue to be subject to discipline of the service, including the obligation to accept service of documents issued in terms of the South African Police Discipline Regulations 2016, and be available for the duration of the disciplinary hearing. You must immediately hand in your appointment certificate, access card, and state equipment, e.g. laptop, firearm, and for future communication in this regard, leave a contact number with your supervisor or keep your official state-issued cell phone. Signed, General S.F. Masimula, National Commissioner of the South African Police, dated 9 February 2026.
Thank you. Let's go to TM2.
TM2. Rosie Resant, state under oath in English. I am a colored female with identity number. I will not read out the identity number. 52 years of age, residing at, I will not read out the witness and the phone number. I'm a brigadier in the South African Police Service, attached to the Organized Crime Investigations Division, Detective and Forensic Services at the Section Head Operational Desk and Project Investigations at Watch Hayes Building, 231 Francis Bart Street, Pretoria. On Wednesday, 11th February, I requested Lieutenant Colonel Bales, the Subsection Commander, Movable Government Property and Service Supply Chain Management Detective to provide me with the SAPS 108 printout from the system 471-35281-3 Sergeant Fannie Nkosi. On the same day, I met with 7135281-3 Sergeant F in the basement of the above-mentioned work address as per his SAPS 108. I was with Captain Henrik Marame from Supply Chain Management Detective Service. The said printout was provided to me, and Sergeant Fannie Nkosi received items as per the SAPS 108 attached as per Annex 1 and handed the following exhibits to me. One pistol Beretta PX P-4 with serial number PX393556. 2 magazine pistol Beretta 30 rounds 9x19mm caliber light. 1 flashlight mag light 3 cell. 1 time CPU laptop Pentium Toshiba with serial number 7132623/20170130. 1 times jacket reflector complete. 1 time handcuffs with 2 keys. 1 times bullet vest, bullet resistant, gray with serial number 00001667773/20170127. 1 rifle with serial number 350871. 2 times R5 magazine, 72 times 5 R5 live round. 1 appointment certificate for 7135281-3 Sergeant Fannie Nkosi. 1 access card to the building. According to the SAPS 108 printout, Sergeant Nkosi was issued with 30 times 9mm rounds, and I hereby confirm that I received 30 times 9mm rounds. The rifle, however, is not on his SAPS 108. I can therefore not confirm the number of rounds received. I can, however, confirm that I received 72 times 5 live rounds from him. I immediately handed the items 1 to 13 as outlined in paragraph 3 to Captain Henrik Mareme from Supply Chain Management Detective Services. No stun grenade reflected on the SAPS 108 of Sergeant Fannie Nkosi. He did not indicate to me that he was in possession of a state-owned stun grenade, and he did not hand in any stun grenade to me. The following items appeared on the SAPS 108 printout for Sergeant Fannie Nkosi, but not handed in or received from Sergeant Nkosi. 1 kit cleaning pistol Beretta, 1 router Huawei with serial number E57883/2308CA. 1 cord retention retractable, 1 safe pistol domestic wall M, 1 haversack, 1 Bexton tonfa rubber. Sergeant Fannie Nkosi indicated that he forgot the above mentioned items and will submit it soonest. I also didn't follow up in this regard, and the statement was signed on the 10th of April 2026 and commissioned by Sergeant Madlanga. Together with this, Your Worship, is a printout which has been marked.
Do you wish for these documents to form part of the evidence, ma'am?
Yes, Your Worship, may the documents form part of the exhibit.
Right. Let's deal with the first one, that is the notice of suspension, TM1. Any objection, defense, that this document be accepted as evidence?
None, Your Worship.
Thank you. The second document being an affidavit deposed to by one Rosie Rasand. Do you have any objection that it be submitted as evidence?
None to that as well, Your
And
Worship.
also, do you confirm that they don't need to be interpreted to your clients?
No, Your Worship.
All right. TM1 as well as TM2, those two documents, I will accept them as evidence and mark them jointly as Exhibit C.
As the court pleases, Your Worship.
Yes, State, anything further?
Yes, Your Worship. Your Worship, the affidavit of the investigating officer also alluded to a search and seizure warrant, which took place on the 2nd of April, 2026, and Section 29 of the Cybercrime Search and Seizure, which took place on October 2025, the 8th of October 2025.
I have the search and seizure warrant, which is dated the 1st of April 2026, that was signed by Magistrate Khan. The other document that you're referring to, which document is that?
Your Worship, is this?
Oh, yes.
Yes, the document.
Right. Do you have any objection, defense, if I accept the search and seizure warrant?
None, Your Worship.
Right, the search and seizure warrant that was authorized by Magistrate Khan of Pretoria North, accepted as evidence, marked Exhibit D.
Has the court ruled?
The document is referred to, which is the search and seizure warrant dated the 8th of October 2025, accepted as evidence, marked Exhibit E.
Has the court ruled, Your Worship?
Yes, sir.
Thank you, Your Worship. That is the evidence for the state.
Thank you. By the way, Advocate,
Yes, Your Worship.
your TM1 and TM2 apologies, you had attached them to some of the documents.
Oh,
Hence the misunderstanding. So your evidence is from Exhibit A all the way to Exhibit E.
Yes, Your Worship.
Right, defense, are you ready to address or what? I'm not even sure what time it is.
It's we still have time, Your Worship. The court time is still on our side.
Okay, Miss Antonio will tell me. Miss Antonio, what's the time? please?
It's 20 past, Your Worship.
Past 3. Oh, it's
If I may turn my back just a second, Your Worship, before I address Your Worship.
yes to me.
Your Worship, I
Wait for your colleague.
to come.
You can't address me whilst your colleague is not here.
Please.
Thank you, Your Worship. I'm ready to address the court, Your Worship.
Yes, you may proceed.
Your Worship, before my colleague addresses the court, I just wanted to draw it to the attention of the court that the investigating officer informed me that the accused must be at Postponement by 4 o'clock. Just to put it out there, Your Worship.
Okay.
Thank you.
Your address, counsel, how long is it going to be?
Your Worship, if I'm not going to be done by 4 o'clock, I will have to come back tomorrow. If the court is inclined to hear this matter tomorrow, because it's urgent. Even now, my client is complaining that the matter must be postponed. I don't know why Hosimamburu is closing before 4 o'clock, but people are leaving from court at 4 o'clock.
Well, Advocate, I will tell you free of charge.
Yes, Your Worship, I think I need that.
It is a norm that we have to make sure that whoever is in custody, we finalize the proceedings latest by 3:30, and then if we are late, it can only be around 3:45 for safety reasons. And also there are other measures that have to be taken into consideration. There are regulations at the present, and obviously we have to take that into consideration. But let us not waste the court's time.
Yes.
Let us deal with the matter itself and see how far we can go.
Yes,
So
Your
you are
Worship.
saying that you will not be able to address the court soonest. You'll only be done after 4 o'clock.
I won't finish before 4 o'clock, Your Worship, but I will stop at 4:15, as you indicate, Your Worship.
Is it going to help? Remember, I'm also human. If you address me today and then you carry on tomorrow, can't you do it tomorrow in one piece instead of 2 pieces?
That you will have to understand, Your Worship, my client. I don't have any issues with that.
We have the whole day tomorrow. I'll be sitting in this court if obviously the state is also available.
That's a court, please, Your Worship.
Are you available tomorrow?
No, Your Worship, tomorrow I had a trial, that's a partly head matter continuing at the High Court from tomorrow up until Friday. And I was asking my colleague, Advocate Patel, is also attending court in Benoni tomorrow, so we're not available tomorrow.
Okay, let's see how far we can go. We can address cancer.
As a court, please, Your Worship. Your Worship, I
We'll
want
deal with the issues of availability
afterwards. Yes, Your Worship. Your Worship, the first issue that I want to place it on record that I'm perturbed by is the issue that we owe a duty to be honest as the officer of the court to you, and also to be collegial to each other in respect of addressing the court and the issues that they come out before this honorable court. However, Your Worship, be that as it may, I have prepared the short arguments. If I may hand up the copy of my heads of argument, and I will also hand the same to the defense, to the state.
Yes, you may proceed.
Your Worship, I have referred you in my heads of argument in paragraph 4 or 5 of my heads of arguments in the matter of state versus Zuma. And I've just referred you to the remarks that were made by Van der Merwe J in that matter. And I'm not going to read it into record for the sake of time, but what the learned judge said in that court is that as a judicial officer, you owe the duty to justice, if I may paraphrase. The court should not be influenced by any other issues that are outside of what this court has to determine, and specifically in the case of Mr. Nkosi, the bail application. What you need to confine yourself in, at Your Worship, is whether, looking at the facts that have been presented by Mr. Nkosi, Mr. Nkosi will be able to stand his trial and or not, based on the facts that are before the court. And before I go any further, Your Worship, I want to refer to what appears at paragraph 37 and 41 of Mr. Nkosi's affidavit in respect to the issues that have been raised by the state in regard to the passport. These are the proceedings that are sui generis, Your Worship, and I will request Your Worship, when you are looking at the context of paragraph 37 and paragraph 41, you should not read them in isolation. And I can confirm, Your Worship, that I'm in possession of Mr. Nkosi's passport, and Mr. Nkosi is willing to hand over the same passport to the investigating officer if the court were to impose such conditions. Your Worship, the grounds for opposition, if I may state them, they appear, Your Worship, from the summary which starts at page at paragraph 11, which is at page 19 of the investigating officer's statement. And those are the grounds for opposition that have been put forward by the state. And I will request the court to confine itself to the issues that are raised from paragraph 11 up until to page 26 of this affidavit, because in my opinion, or in my analysis of this evidence, that is the gist of opposition of this bail application by the state. And if I may take your worship through what has been stated in paragraph 16.1 at page 22 of the affidavit opposing this bail application. They say that the applicant was found in possession of multiple firearms, large quantities of ammunition, and explosive device, which is prohibited by law. These firearms, Your Worship, that were found at my client's house, it is not alleged these are unlawful firearms. My client has the permit to hold those firearms, and the contention that it is unlawful to have 7 firearms, it does not have merit, Your Worship. It is not merited. As I have indicated, that my client is disputing that he was found in possession of stun grenade, and the court will note in the photo album that we have been provided by the state, from the pictures that appear to have been complied by Warrant Officer S. Ndumiso, there is no picture of a hand grenade in all these pictures, from picture 229 to picture 274 of the pictures. There is no picture of the hand grenade, and the accused is disputing that. I know, Your Worship, I'm not here to go to the merits of the matter. However, if you look at these pictures, Your Worship, there is no indication of the date. When were they taken? What time were these pictures taken? But what is contained is that these pictures were taken by this Warrant Officer S. Ndumiso, but there is no date when was these pictures taken and at what time. And Your Worship, when you look at this exhibit B, there is no information of such particulars. And one will look at those pictures, Your Worship. You will take the pictures that have been taken from the motor vehicle. You look at the pictures that were taken where what looks like a mattress or a bed. There's no time when these are taken. And in a response that this court had to stand this matter down for almost 2 hours, the state indicated that they wanted to deal with the issues that have been raised by the applicant. And in doing such, Your Worship, there is no indication as to the time. But I want to move on, Your Worship, to paragraph 16.2, that there's a likelihood of evading the trial, section 60, 4B. It says that the seriousness of the offense might lead to him evading this trial. Your Worship, because of seriousness of the offense. In terms of Firearm Control Act, the sentence for contravening section 128A is 5 years, Your Worship. And taking into account of the 5 years, it's 2.5 years taking to the issue of parole in South Africa, Your Worship. And in this paragraph 6.2, there is nothing that has been given by the state that the applicant will evade his trial if he is released on bail besides this issue of a lengthy trial. The applicant has indicated that he's got a house that is valued at 1,500,000. He's got a kid and a wife that is employed with this jurisdiction of the court. Why will then the applicant evade the trial if the applicant is emotionally tight and there's family ties within this court's area of jurisdiction? In paragraph 16.3, they are alleging that he might interfere with the witnesses and also the evidence. They are basing this on section 64C. Your Worship, there is no merit in this contention for the following reasons, Your Worship. My client has been suspended from his place of employment. He does not have access to any systems that are used by the police. And the state is alleging that he might influence the investigation and he might be working with other people within South African police services. And there's no evidence that has been presented by the state that Mr. Nkosi is working with other people from within the SABS, Your Worship. And this notion that Mr. Nkosi will tamper with the evidence in paragraph 6.4 is not substantiated, Your Worship, because what you have to look at, Your Worship, is whether a police officer that is suspended does not have access to his work. Can he be able to interfere with what is happening within the police? And it is my answer, Your Worship, that no, Your Worship, there is no evidence that there will be interference. The people who were at his house on the 2nd of April are the members of the National Task Force. And those are the people that will have to testify in regard to what they say they saw there. And it is my submission, Your Worship, that these police officers of National Task Force, there's no evidence that my client may be able to influence those witnesses, Your Worship. In paragraph 16.5, they are alleging that he might undermine the criminal justice system, and they rely on section 64D. This is the first time that this accused is arrested, Your Worship. And I will understand that if they say that Mr. Nkosi was once released on bail and now he's back before this court again, that will amount to undermining the criminal justice system, Your Worship, or the bail system. And as the facts stand before you, Your Worship, there is no evidence that Mr. Nkosi will undermine the public justice system. And they also state this, Your Worship, in paragraph 16.6, that the applicant is entrusted with enforcing the law, Your Worship. And it is common cause, Your Worship, that whether you're a police officer or an advocate or a magistrate, one day there might be circumstances that may lead to your arrest, whether wrongful or rightfully. But we cannot say because you are a magistrate, you are responsible for enforcing the law, you are not entitled to be released on bail. Because, Your Worship, what you must consider is that these are still allegations that still need to be tested before the trial court, and the trial court will have to make determination on the evidence that is presented before it. And it is not for this court to go in detail in what the evidence of the state, whether the state's case is wrong or not. And if you look at section 64A to E, Your Worship, it is clear what you have to consider in order to grant or refuse the bail. And it is my contention, Your Worship, that based on the facts of this matter, there is no evidence that Mr. Nkosi will not stand the trial. Now, Your Worship, let me take you to this issue of the dockets. The dockets that the state has indicated they are from Musina, Rudaport, and various police stations within this province and Limpopo province, Your Worship. And in the affidavit, in support of this bail application, there's a contention, Your Worship, that was made by the applicant that he is involved in matters that emanate from Musina and within other Barasa police station because there was a task team that was established by the President of this Republic of South Africa and also the National Commissioner and the suspended Deputy National Commissioner. And there was no evidence that was presented by the state to refute such, Your Worship. And my client maintains that he was in possession of these dockets because he was involved in the investigation of these matters as stipulated in the affidavit in support of the bail application.
Right, Advocate, I might have to stop you right there. We'll carry on with the address on the next appearance.
There's a court ruling.
Let's fix the issue of the next date. When is your next available date, ma'am? The soonest, Advocate?
Monday, Your Worship.
You have no availability at all prior to the 20th of April?
None, Your Worship.
Yes, defense, Monday the 20th?
Your Worship, this is the abuse of the processes of this court. As I've indicated to you, Your Worship, that the bail application is an agent application by its nature. Today is the 13th of April. This matter started from the 2nd of April, Your Worship. And they are, in their affidavit, but I will deal with it, Your Worship, what they say in their affidavit. This court cannot just rubber stamp the postponement that are sought by the litigants before it, Your Worship. As I've indicated, this application is agent, Your Worship. And to grant the postponement until a Monday, Your Worship, that is not in the interest of justice and it does not speak to what Section 35 of the Constitution states, Your Worship, as far as the bail application is concerned.
I would have sympathized with you, Advocate, if I didn't have the following problem. This morning, we had to wait for you until 10 o'clock. We lost 1 hour because of your non-availability. If you arrived early, we would be finalizing these proceedings right now.
Your Worship,
The worst case scenario, we would have had to postpone maybe for judgment, who knows. But we had to wait for 1 whole hour for you, Advocate, unfortunately.
Your Worship, I don't want to go back and forth with you. That's not true because when I came here, I left my bag. I was the first person to come to this court. So I don't want it to be out there that the court had to wait for me for 1 hour. I was the first person in this court and I left the bag, and I also indicated that to my learned colleague when I arrived that I was here, but I just stepped outside to speak with my client.
We couldn't find you, but be that as it may, next time, because obviously we are not going to finalize today. Now I'm speaking to both the state as well as the defense. Let us not lose an hour unnecessarily. Let us use each and every minute fruitfully. It doesn't matter who came first, but let us meet in court exactly 9 o'clock. Let us start with the proceedings. In that fashion, we'll be able to finish. We are here now because of the hour that we lost in the morning. You are right, we shouldn't go back and forth, but as far as I know, I was told that the defense is not there, hence I had to wait until 10 o'clock for me to be able to start with the court proceedings. Now let's deal with the issue of the date. She says she's only available on the 20th. You have objected. I have to give a ruling, obviously, on that. There is no other way. I cannot be unfair and postpone a case to a date when they are supposed to address me, but they will not be here to address the court. Therefore, I'm inclined to give them a postponement until the 20th. My question is, Advocate, are you available on the 20th?
I don't know, Your Worship. Let me find out. Your Worship, the matter will be postponed to the 20th. I will say what to do on that day.
All right, thank you. Thank you, Advocate. Do you confirm the 20th as well, State?
I confirm the 20th, Your Worship.
Right, Mr. Nkosi, please stand up.
If I may tell my Your Worship before you postpone the matter.
Yes, you may approach.
Your Worship, there was an order that was made on Tuesday that he be placed in the hospital section. I request that the same order be made.
Why the hospital wing?
Your Worship, the reason for the special hospital wing is that he is concerned that he might be poisoned while he is in prison. And in the side of hospital wing, there are measures to ensure that such does not happen. And that's the reason why the magistrate to postpone the matter on second, postpone the matter as such.
Thank you. What's your take on this?
Yes, when the matter was postponed at the last occasion, it was indicated that the accused has diabetes. Therefore, the state had no objection with him staying in the hospital section in order to get access to the medication. Although it was not mentioned now, that was...
Was it because of diabetes or was it because of a fear of being poisoned? What was it?
Those were all the reasons that were advanced before the court, Your Worship. That is diabetic as well. I forgot to mention that.
I don't see why a person must be kept in a hospital wing. I'll tell you my reasons now. The hospital wing is reserved for people who are admitted as patients. By merely saying that the person is diabetic, that does not justify being admitted in hospital. And also, my other concern is he says he's afraid of being poisoned. If he's afraid of being poisoned, whether he's hospital wing or general prison population, and I don't see where that is stemming from. I'm not sure if that is the right order that my colleague made, and I'm not inclined to make such an order. Placement of a prisoner in a prison hospital wing is reserved for detainees who require medical treatment, observation, or nursing care. It is not designed for function as a form of protective custody in the absence of any medical necessity. And for me to say, because he's diabetic, now I'm saying that he must be admitted, that will be unfair to the prison authorities. They are mandated to make sure that everyone in their case is taken care of and they are safe. They will exercise their discretion there to ensure his safety. I'm not going to make an order that he be kept in the hospital wing. They will make sure that he is taken care of, that he is safe, and I cannot find any reason, any substantial reason why I must say that he has to stay in the hospital wing. He will stay in the general population. They will ensure his safety, like they have to ensure the safety of each and every detainee in their custody. I am not going to micromanage the prison and say somebody must go here or somebody must go there. They will assess the need, they will assess the possibility, and they will make their own decision. Right, your case, sir, is remanded until the 20th of April 2025 in this court. It is for us to continue with your formal bail application. You'll be kept in custody until then. You may interpret, Ms. Kosana. Right, 20th of April, 8:30 in the morning, so that we can start at 9 o'clock. Thank you. Correct?
All right, please stand.
Yeah, the backup.
When I select